Hi friends, this is Faraz Ahmad Khan, and today I'm going to give you a very short video on the clauses which need to be put into a general contract or a general commercial contract. So the very first clause that you need to put in is the definition clause. Definition clause by it's a self-explanatory. You need to put in terms and frequently used maybe jargons which will be used in the contract, and when somebody reads the contract he will back and forth refer to the definition and then try to make sense of what the contract is. So that's very very important. A more important thing is that if or should the contract goes before the court will also first see what's written in the definition clause, and only then take a then make an interpretation of the whole contract. Uh, Second most important clause is the duration clause, which means basically for how long the contract could be in force. It can be of 1 month, 3 months, 6 months, 365 days, and some contracts are perpetual in nature, which means it's going to renew itself after expiry of 365 days, and so on and so forth. So that is one important clause. And the third is the termination clause. Well, what termination clause does is it provides a window for both the parties to uh, terminate the contract if they feel that the contract that they got into is not really serving the purpose of the business, or whatever the subject matter of the contract was. And again, we have yet another clause which is known as the confidentiality contract. Well, any two party who come into contract, they have this thing in mind that their resources, their um, you know things which are confidential to them, when one party starts working with another party, there is some amount of information exchange, and that maybe that exchange is done on a need to know basis, but still there lies a danger of information being leaked out from one party to another, and somebody who has access on the other side to such information may pass it on to some competitor in the market. So this confidentiality clause makes sure that that does not happen. Another yet important clause is the notices and communication clause. Now it is very important that it happens then that when we are sort of communicating between a client and the party, uh, people keep on changing at the other end. So it's the email remains the same, but the person handling the email is not the same. So it's always advisable to put in a designated email, so that the party knows that if a concern is being raised or any communication is being made through an email, there is this important person on the other side who is going to read our problem, our issues, and then that person is going to address it. So if it is explicitly mentioned that this particular email will be the point of correspondence, things become very easy, and the issues which may potentially arise will never arise. So which is why I think it's a very very important clause to be put into an agreement. Another important clause is the indemnification clause. Now there may be a situation where at no fault of one party, that party suffers a loss, and a third party may step in and say that, listen, because of your service I have incurred some loss. Now let that party be A. Now A will say that, see, I didn't do anything wrong on my part, it was something that my client B had done something wrong. So there was some error apparent on the party's part. So what do I do? So what you do is you make an arrangement with the third party that, okay, will make you good in whatever manner we can, and then this indemnification clause sort of indemnifies you. Your client will indemnify you or make you good, because the the error on the part of the on your client, because of which you were sort of uh, threatened to be sued, if I may say so, or sued, or given a show cause notice of, or for no reason you have to pay some settling amount to that party. So this sort of is, in that sense, a very important clause. Again, one more important clause is no relationship of the parties. The parties have to declare that they are in the full capacity, competence, and they are actually the ones who have the right authority to bind this contract, which is happening between two parties, let's say party A and party B. So that's relationship of the parties contract, and it also says things like they are not the principal and agents of each other, and they are the relationship is simply limited to the subject matter of the contract, and nothing else beyond it, nothing else before it. So that kind of stuff. Then there is severability clause. It basically says that, let's say a portion of a contract is void for some reason, but rest of the portion is not void. So the portion of the contract which is not void will run its ordinary course, while the portion of the contract which is void may be terminated, may be excluded from the contract. So this is what this clause says. Now there is a waiver clause. Now at times it may happen that for some reason a party was not able to fulfill its obligation under some extraordinary circumstances. Let's take example of the pandemic. So the other party may say, look, we are doing business with you from a very long point of time, and we do understand that pandemic did upset a lot of things around. So this time we are going to give you a waiver for like current month or next 3 months or 6 months, and then you have to do a course correction, and then so that things between both the parties normalize, and then the contract is able to run its normal course. So which is why we have this waiver clause. But one thing in mind, that the waiver clause once given cannot be sort of taken for granted, that even on the first waiver which was given by one party to the other party will continue to act in a manner as if the waiver was given from one party to the other party, you know uh, in a perpetual manner, in a very unending manner. No, there is a limit to it. If the waiver is given for 4 months or 6 months, then the waiver means it is given for 6 months, and that's that. In the seventh month, do not expect that the other party will give you yet another waiver until and unless they decide to do so. Now we have something called agreement in entirety clause. Well, it says that what happens in an agreement is that we have the basic text of the agreement, and we also have certain annexures and schedules which are attached to the agreement. So the main text of the agreement plus the schedules plus the annexures plus anything which is added as an extension of that main text of agreement. So all these things put together will form the contract. So this clause basically says these all things, these all documents put together will entirely be considered as one contract. They will not be seen in isolation with the original contract, the main text of the contracts. So this is a very important clause yet again. Again, one important clause is disclaimer of warranties and limitation of liability. Here, what a party does is it sort of disclaims its warranty, whether express, whether implied, whether being advised against it, and sets its maximum liability. That be that as it may, in any scenario, in any case, what we are going to do is we are not going to pay you, let's say, total aggregate of 6 months revenue from the date when first the liability first arose. So that is the upper cap that one party is trying to put in terms of its liability uh, while making a contract with another party. So this is from the commercial point of view, this is a very very important clause. Now another contract, another clause which is very important is arbitration clause. And these days arbitration clause you find in most of the contracts, because it's an alternate dispute resolution mechanism. People prefer going to arbitration and not going to court, and this is basically an out of court settlement where they sort of draw up a separate arbitration clause, and it's a very detailed clause, and then they appoint an arbitrator, and it takes some time, and like 2 months, 3 months, maybe 6 months, and then the problem or the conflict or the friction or the dispute, whichever may have happened between the parties during the running of the contract, uh, the arbitrator will try to sort of figure it out and try to strike a settlement between them. So this arbitration clause is very important, especially in international agreements. This is of great importance. Our IPR clause is very important, because IPR clause says that whether it's the logos, whether it's the trademarks, whether it is any other information, or whether it is anything which has been which is the intellectually independently developed thing of a party. So the party says that maybe you can have access to it, but then that access will be on a very limited basis, and that should serve the business relationship or the contractual relationship which we are having between us basis this contract. Beyond that, you are not allowed to use any of these intellectual property or rights over it. So this is yet another important clause. um, Another important is governing clause, or otherwise known as jurisdiction clause. So basically a contract is made between party A and B, but then should there be a conflict, should there be a dispute, where is it that they're going to go and settle? It should be some place, some city, some country, and then obviously there will be applicable laws of that country, the law of the land. So jurisdiction clause is mentioned, and then both the parties say that okay, fine, if we do have some conflict, we do if we do have some dispute, um, this is the jurisdiction which we choose for ourselves, and we'll go to a court which lies in the jurisdiction. Let's say the jurisdiction is of New Delhi, so we'll go to a court in New Delhi, and there we will settle our differences in front of the court. So this is yet another very important, very very important clause. Survival clause. Okay, survival clause is basically it says that even after termination of the agreement, there are certain obligation of both the parties towards each other. For example, confidentiality clause. Both the parties may still remain in possession of confidential information, and the danger may remain that they may pass it on to some other competitor in the market. So what this survival clause says that even after the termination of agreement, um, even after the termination of agreement, the parties will behave in a manner as if they were still existing into a contract, and they were not supposed to pass sensitive information to any third party. So this sort of put both the parties into a bind, and it's actually a very good clause to be put into a good agreement. Uh, Assignment clause. Well, assignment clause is basically there is a contract between party A and party B, and party B says that I'm going to sell my business to party C. So what happens to all the obligations of party B that it had unto party A? So the new party C, who is taking over the business party B, will say, all right, I will discharge all my obligations and I'll do whatever needs to be done as far as this contract with party A was is concerned, and you don't really need to bother. So a separate agreement will be constituted between party C and party B to make sure that the already existing contract between A and B does not get affected. So this clause makes sure that this aspect is taken care of. And general clause. Well, general clause is a general clause. The thing is that Indian Contract Act tells you how should you, the do's and don'ts of a contract, but it does not tell you how it does not give you a template to make a contract. So you have to draw a contract based on your mind. It's entirely your foresight, entirely your experience, entirely your your in-depth knowledge of understanding that what exactly is it that the clients are expecting out of each other. So on the basis of that, if any clause or any terms or condition that remains, covenants that remain, which cannot be put elsewhere, then you put a general heading, and one by one you put all those terms and conditions under the general clause. And hopefully, if we try to put in all at least these 15-20 clauses into a general contract or a commercial general contract, it will become a good contract. So the idea of making a good contract is that the business between two parties runs smoothly, seamlessly, without any hiccup, without making both the parties without making much of a trouble for each other, and the business relationship between them uh, grows, and the business between them flourishes. So as a lawyer, our job is to facilitate uh, the growth of good business, and it obviously contributes to economy. And yeah, that's all. Thank you so much. Thank you so much for watching the video. And please, yeah, do if you did like my video, subscribe to the channel and press the bell icon for notification. Thank you so much for watching. See you again. Bye bye.